All right. Thank you all so much for being here. It's been 2 years since we've been in person. We were online only last year, and it's just a treat to see everyone and give hugs and chat over break. So thank you all for joining us today. Um, our last speaker, I'm a little biased. He was one of my former students, and I served as the chair of his thesis committee. One of my favorite people in the world is Casey Terrell, who's an associate at Crowley and Fleck at their office up in Sheridan. Casey is originally from Pinedale, Wyoming, and now gets to live in Sheridan. He is a lucky guy. He litigates energy, real property, and general commercial disputes. He also maintains a broad administrative law practice, assisting clients with navigating regulatory requirements and processes related to state and federal public lands. In the project development context, Casey works with his clients in developing strong working relationships with landowners and co-developers to prevent conflicts before they arise. Casey graduated from the University of Wyoming in 2008 after completing his dual degree program to receive both an MA from the Haub School in Environment and Natural Resources, as well as his JD. I just want to pause there real quick. We have a lot of JD students, JD MA students in the room. So these are students who are not only getting their law degree, but concurrent with that, they're earning a master's degree and writing a thesis. So I just want to commend them for that effort. And those of you who hire law students, give those JDMA students a close look because they are among our best and brightest. So Casey was the past chair of the ENR section for the Wyoming State Bar, and he's the current vice chair of the Young Professionals Committee for the Foundation for Natural Resources and Energy Law. And this is so cool. He was recently recognized as the American Bar Association by the American Bar Association as one of the top 2022 lawyers on the rise in their top 40 young lawyer program. So super proud to have Casey here with us today. And Rebecca, you would be proud of Casey because he does a lot of really great community service in Sheridan, Wyoming as well. So he's following in your footsteps in that regard. So Casey, please join us to come talk to us about renewable energy and oil and gas.
Howdy, everybody. As Temple said, my name is Casey Terrell. I practice with Crowley, Fleck in Sheridan, Wyoming. Born and bred Wyomingite, as she mentioned, from Pinedale. You don't meet a lot of folks from Sublette County out and about, so I'm usually proud to have the distinction of being one of the only ones. We have two in the room, Miss Karen Bud Phelan back there as well. Like some folks that have gone before me, I want to make clear as I start that these views are my own, not the views of my employer or my clients. Have to get that out of the way, the formal legal stuff. So I'm excited about talking to you about this topic. I first got really interested in this through my practice, and then have the opportunity to work on a paper this last summer for the Foundation for Natural Resource and Energy Law with Darren Shear and an attorney out of Ohio named Kara Hernstein. So we took a real deep dive into this subject. And so after my presentation, if you're interested in learning more, feel free to obviously reach out to me. I'd be happy to chat about it. But also feel free to take a look at that paper. It's really informative. So I really like a roadmap to the point where my wife, we have discussions and she's like, please don't give me a roadmap. So I want to talk about first the origins of the accommodation doctrine and work our way up to the case of Lyle versus Midway Solar. If you're not too familiar with the subject matter area, you might be asking why we're going to start out with the accommodation doctrine. I kind of view it as, in order to play a football game, you got to know what the field is. If you want to build a house, you got to have a foundation. And so keeping that in mind, the accommodation doctrine serves as the basis for navigating these relationships and co-development as we know it. From there, we're going to talk about 3 examples of state-specific permitting regulations and regimes, and also a little bit of a lack of state permitting regulations and regimes, and how those play into reconciling conflicts between renewable energy and traditional energy development. Next, we're going to talk about federal policies on co-development, or what we do know about how federal agencies may treat co-development. And then last, and I'd like to think, most importantly, we're going to talk about some practical takeaways for co-development of projects and specifically co-development agreements and how those can be helpful in your practice. I recognize that I'm the last speaker of the day. I tried to think about this a couple different ways. I thought, well, maybe folks will be gone. Maybe they won't be here. Maybe their attention span will be short. And then I thought, you know what? The most important pitcher on a baseball team is the closer. So that's how I'm going to choose to look at the talk today. So this is Signal Hill Oil Field in Los Angeles County, California. This is in 1923, well before we had federal regulations requiring analyses for things. But I was looking at this picture the other night and thought, can you imagine just the permitting shenanigans that would have to take place nowadays to even get close to anything like this? When oil and gas production first took off in the United States, we saw a lot of conflicts between surface use owners and folks trying to make use of the mineral estate, especially before we had the advent of horizontal drilling. When we were stuck with vertical wells, you had to put that well where your resource was, regardless if there was a house or whatever there. Before we also had state regulatory schemes appropriately apportioning production, we also had those everywhere because folks were trying to get whatever share of the resource they could. So it was only natural that out of that, there came conflicts between folks that own the surface estate and folks that look to take advantage of the mineral estate. Now, we all know that the mineral estate is dominant. What does that actually mean, though? It means benefited, but not necessarily superior. When an individual or an entity that owns mineral rights is exercising those rights, they still have to do so with due regard. That's what the common law says. And there's good reason for that, right? Mineral interests in and of themselves have sort of a quasi-public nature. We take energy production, and that's for the good of the whole. It powers automobiles. We use it for electricity production, all manner of different things. And so because of that public good that's derived from the mineral estate, we give it a special importance. Now, at common law, there wasn't a great balancing test between the surface estate and the mineral estate. However, because of that quasi-public nature and the dominance of the mineral estate, courts generally said that mineral estate owners to access those minerals could even impair existing uses of the surface if that was what was necessary to develop the minerals. The sort of line in the proverbial sand that was drawn at common law was you weren't allowed to do so if you negligently inflicted damage in the course of pursuing those minerals, and that's where it sat for quite some time. Now, there's a lot of unique aspects of mineral development that we're going to talk about in a minute that are also shared with renewable development. The mineral developer doesn't get to choose where that mineral is located. And when I say traditional minerals today, to be clear, I'm talking about oil, natural gas, coal, things that we traditionally pull from the ground. And those, with some minor exception, are where they are. And without access to getting to where those things are, the resource is wasted. As we noted, allowing the mineral estate to be dominant promotes economic development, which in turn gives us affordable electricity and also energy independence and national supply. If you have never done so, I would encourage you to head north on I-90, first of all, because you're going to wind up in Sheridan and it's great. But second of all, because on your way, you can stop at the Salt Creek Oil Field Museum, which is fantastic. They have a lot of examples there of cool historic oil and gas development in the state of Wyoming. But one of the things that's covered there a little bit is the Teapot Dome scandal, where the United States set aside certain mineral interests that then were leased, and it turned into a huge political situation. But that all speaks to national security and how energy's relationship is tied to that. So when we shift gears and kind of look from a modern perspective with renewable energy development, we see a lot of the same things. We don't necessarily get to choose where the best wind is located or where we have the best sunshine. Without the ability to access those spaces, we can't pipe sunshine elsewhere, or else we would have it going from California to a lot of other places. And if you aren't able to access it, the resource is wasted. Again, more diversified energy, as you've heard multiple folks talk about today, helps us be more resilient in terms of our energy grid, and not only makes energy more affordable, but also helps with energy independence and national security. The interesting caveat as far as the similarities between the two is obviously the climate benefits of renewable energy compared to traditional energy development. And that's what's pushing forward this sort of confluence that we're going to talk about in just a moment that is really resulting in some new law. So today, I was doing a lot of thinking about why exactly this matters, why it's so poignant. And I really like the way that I phrased it here, and so I'm not one to read off his slides, but I think it's important that we understand this dynamic. The fact that natural resource development of the surface estate shares a lot of the same characteristics that were previously held by the dominant subsurface mineral estate is likely setting the stage for some major evolutions in the law as far as how that relationship is governed. And that's why I think this subject is so important. So we're about to talk about several Texas cases. Being from Wyoming, I always joke that Texas is like a low budget version of Wyoming, which is not fair to our friends from Texas. But why we're talking about these Texas cases is because that's where the accommodation doctrine primarily started. A lot of Texas mineral development took place prior to development in other parts of the country. And so accommodation doctrine cases primarily come out of Texas. And we look to Texas as sort of the bellwether for how accommodation doctrine law, as far as the common law goes, is shaped. So the first substantive case dealing with the accommodation doctrine was Getty Oil Company versus Jones. Getty dealt with a situation where there was a split estate, somebody different owned the surface and owned the mineral estate, and the surface owner already had an existing center pivot sprinkler system. The mineral interest owner wanted to install pump jacks that would interfere with usage of that center pivot sprinkler irrigation system. The surface owner said, listen, this is the only way that I can go about this due to labor shortages. That was the testimony that was put forward at trial. And he said that the surface owner at trial also presented evidence that reasonable but more expensive alternatives were available, such as burying the pump jacks or utilizing hydraulic pump jacks on the part of the mineral interest owner. So the court took a look at this and sort of jumping off of the due regard balancing test that had been used previously, weighed the potential impact of allowing the pump jacks and how that would impact the surface owner against requiring some sort of different action on the part of the mineral interest owner to go ahead and harvest those minerals. Law students' point of fact as far as practice goes, burden of proof is so huge. And the court noted that the burden of proof in this situation was on the surface owner to demonstrate the inconvenience or financial burden of continuing to use an alternative method so great that it would make that alternative method unreasonable. And the court said because of that, if there is no reasonable alternative, then the mineral owner can move forward with the method that they had proposed. In the end, the court held that where there's an existing use by the surface owner, which would otherwise be precluded or impaired, and under established practices of the industry, there are alternatives available to the lessee where the minerals can be recovered. The rules of reasonable usage of the surface may require the adoption of an alternative by the lessee. So this is the first time that we're seeing this dominant mineral estate, a court looking at that and saying, this might not be the golden ticket that it's been previously billed to be. There might be some more intuitive limitations on this just beyond negligence. So quite a bit of time goes by. That was a 1971 case. And then the Texas courts have the opportunity to examine the issue again in Merriman versus XTO Energy. In that situation, there was a farm and ranch operation, 40 acres, and they used that 40 acres for a cattle sorting facility. They said that XTO's proposed, the defendants proposed mineral extraction activities would otherwise inhibit or interfere with their ability to use the property to sort cattle. The Court of Appeals argument sort of centered around whether there was alternative agricultural uses for the property sufficient enough to show that accommodation was possible. In that, the court said that the surface owner must demonstrate, one, that the lessee's use, talking about the mineral lessee, completely precludes or substantially impairs the existing use, and two, there's no reasonable alternative method available to the surface owner by which the existing use can be continued. If only one method for developing minerals, that method may be used regardless of its impact on the surface. So if that's the only way that you can get it done, then you have a right to get it done. Now, again, if there's a reasonable industry accepted alternative, then likewise, you must use that as the mineral owner. Ultimately, the court rejected XTO's argument regarding the surface owner's short-term leases as an alternative location for cattle sorting. The Texas Supreme Court also rejected the Court of Appeals finding that alternative agricultural uses may be available to the surface owner. They said just because there's in the broad spectrum of possibilities something else agriculture related they could do, that doesn't mean that it's a reasonable alternative. However, again, talking about that pesky burden of proof, the court said despite that, the surface owner didn't meet the burden of proving that he didn't have a reasonable alternative and no means of maintaining his cattle operation on that 40-acre tract. So the Merriman case is significant because the court is again expanding on what exactly is required and how they're going to go about testing this reasonable use. And it's the first time that they say if there is a reasonable use out there, it has to be operated. So then comes Vertex Operating Company, Inc. versus Bowerly. This is one of my favorite cases just based on the facts because the rancher comes to the court as the defendant, and the main issue here is that they are using a helicopter for taking care of their cattle and hunting, which just sounds like a great life to live. But so Vertex wants to operate and get to the minerals that are underneath Bowerly's property, and the surface owner says, listen, without this helicopter, we don't have a reasonable alternative for hunting and controlling game on this huge ranch. It's 8,500 acres. And where this came to a head was the mineral interest owner or the mineral interest lessee said, we want to put up power lines in order to service our well sites. Obviously, I don't fly a helicopter, but I imagine that power lines and helicopters don't go well together, especially if you're low to the ground trying to do game control operations. So the surface owner says that the power lines would completely preclude or substantially impair their ability to keep using helicopters for their game control operations. They also said that there was no reasonable alternative method that they could utilize, and they claimed that there was reasonable, customary, and industry-accepted alternative methods for powering these well sites that were available to the mineral developer. The court said, okay, yeah, power lines and helicopters probably don't mix. We get that there's sufficient danger there. We don't have to consider whether every single power line is dangerous. We're looking at this on the whole. But definitely we agree with you, landowner, that the inconvenience and cost of other hunting methods makes this unreasonable. And so they said buried power lines or diesel gas powered pump jacks were an industry accepted alternative, despite the additional cost of roughly $200 to $300 per well per month. And so whereas in the Merriman case, the court had said, listen, there's this possibility out there that there may be industry accepted alternatives that mineral lessees are going to have to use. But Vertex was one of the first occasions where the court said, listen, this is one of those, and we're going to require you, mineral lessee, to follow through on that. So that brings us to Lyle versus Midway Solar. As an aside, before we look at the specific facts of Lyle versus Midway, I want everybody to keep in mind the communication that did not happen in this case that ultimately resulted in where it wound up. So the surface owner owned 350-acre parcel without any ownership of the underlying mineral rights. The surface owner entered into a lease with a mineral leasing company, Midway Solar, that in part said that they were free and they granted them the free and unobstructed use and development of solar energy resources for up to 55 years. In that lease, interestingly, somebody saw this coming down the pipe because there was a clause in there that said that the surface owner had no right to control the underlying mineral owner's activities. Interestingly, that solar lease also included provisions that provided for certain drilling tracks within the surface that the solar company was leasing. So they made some menial efforts to try and resolve conflicts before they happened. But the key part there is highlighted in red, which is they set up these drilling windows with no input from the mineral interest owners. So it was basically like, hey, we got you this present. Here it is. It's not what you asked for. And turns out it wasn't really that helpful. As you can see on the map, we'll see if this, sweet, the laser does work. On the screen behind me, the designated drill sites were this 80-acre tract up here, and then the 17 acres down at the bottom. As you can see, Midway ultimately covered approximately 215 acres or 70% of the parcel in solar panels. They never obtained surface waivers from the mineral interest owners under the 315-acre parcel. And my favorite part of the case is they didn't do that, but they did obtain them from adjacent mineral interest owners, which is a practice pointer that we'll get to later on. So after these solar panels were installed, a mineral interest owner that owned 27.5% of the minerals underneath that track brought suit for trespass and breach of contract. They said that by putting up the solar farm, the surface owner had either impaired or greatly diminished the value of their mineral estate, and they sought a permanent mandatory injunction to remove the solar panels and transmission lines. A couple significant facts that the court ultimately looked at. The Lyles, the mineral interest owners who brought suit, had never leased their minerals, had no plans to lease their minerals. They didn't commission geological studies. They entered into no drilling contracts, and they had received no requests to purchase or lease the minerals. In sum, the court said they had no plans for drilling any wells in any sense of the word. So ultimately, the court came down and said, all right, Midway, as the surface lessee, you have the right to use the surface. Now, the Lyles, being the mineral interest owners, you guys also have a right to use the surface. They have to do so, however, the Lyles or their subsequent lessees have to do that in the development of their mineral estate. However, because the Lyles had never sought a lease, had no offers to purchase, they had done nothing to demonstrate that there was any interest in their minerals or they were trying to use them. The Texas Court of Appeals in El Paso ultimately ducked the issue just a little bit by saying, if they're not exercising their right, there's nothing to be accommodated. Unless and until the Miles seek to use their right, whether that's by filing drilling permits themselves, trying to sell those minerals, entertaining lease offers, until that happens, the accommodation doctrine is not triggered. It's not at issue in the case. They said, interestingly, in more or less in dicta, that a party is not required to undertake a feudal act. So if it's absolutely impossible for you to even entertain a lease on there, you aren't precluded from a claim for damages. But unless and until there's actual or planned development, we can't do anything to help you. So that's a little bit of background on the accommodation doctrine. It's how the common law says, okay, if we have two folks that are entitled to use some combination of the surface and the subsurface mineral estate, how are they supposed to get along together? We see that in the beginning, although the mineral estate was primarily dominant in some ways beyond reason a little bit, that sort of degraded over time. And we see the ship almost, if we think about the law as a pendulum, it was swung one way, and now we see it starting to swing back the other way. Now, the second piece of this discussion is going to cover a couple different state regulatory regimes. These are important because when it comes to reconciling conflicts with co-development, a lot of times there's not a great opportunity to do so. If you're a mineral interest owner who wants to develop your minerals, in most states, except for Colorado, which we'll get to, you aren't required to provide notice to the surface owner. And vice versa, a surface owner, if you're wanting to develop your surface, you don't necessarily have to give notice to the mineral interest owners. So because there's going to be this inevitable conflict if mineral interest owners want to develop, you have to look for opportunities to advocate for your rights and try and solve these problems. Now, you can do that proactively through agreements, which is what I'm going to advocate to you at the end, but your only other opportunity are through regulatory schemes. And whether that's you having certain administrative rules or statutes in your state that protect or otherwise allow you the opportunity to have input in that process, whether it's through objecting or permitting, or whether it's the ability to have input at a public hearing and try and persuade the opinions of public officials, that's your opportunity to battle these things out. So looking to Colorado first, Colorado has this statute listed up there. I'm not going to list the numbers for you because I'll inevitably mess them up, but it requires surface owner notification of development to identifiable mineral interest owners. So to put that in more layman's terms, if I own surface in Colorado, but not the mineral estate, or not even all of the mineral estate, and I want to develop my surface, I have to go out and provide notice to readily identifiable mineral interest owners. Now you can see how this may be helpful in addressing conflicts between folks that want to develop the surface and are making substantial investments financially in that, and individuals who someday down the road may want to try and produce those minerals. Notably, the main consequence for failing to do this is statutory penalties if you fail to provide that required notice. The Colorado Oil and Gas Conservation Commission has also put in drilling windows. So in their drilling scheme, their oil and gas regulatory scheme, they've placed drilling windows, which for specific formations in specific parts of Colorado, they say that this is a designated drilling window that you can use to develop the minerals. And this is the Colorado Oil and Gas Commission trying to get in front of these conflicts by saying, here, we're setting aside this piece of land from the beginning as surface that mineral interest owners can use to access their minerals. Now, is that a perfect system? Absolutely not. As we discussed, traditional minerals don't move. They are where they are. And so wherever you put these drilling windows doesn't necessarily mean that they're going to be effective for purposes of accessing the minerals. Now, we have a lot more ability to use them effectively with the advent of horizontal drilling, but that's one, only applicable for oil and gas and not necessarily coal, and two, doesn't always mean that it's still going to be economic. So then we look at Wyoming as an example and see what they have going on regulatory wise for renewable energy project development. So under 18.5.505, proposed developers of wind energy facilities with an estimated cost of over $253 million must submit an application to the relevant Board of County Commissioners. So if things go south and you're a mineral interest owner and you don't necessarily handle your business with your surface owner in advance of hearings like this, you're going to be fighting it out at a local county commissioners meeting about these proposed projects. For those of you that are attorneys in the room, I suspect you would agree with me. For those of you that are not, you might want to defer to us on this, but you would much rather work on this ahead of time than be fighting with somebody else in front of elected county commissioners that are often not attorneys. The rules of evidence don't apply. They're lay folks. They have voters to answer to. They are not the objective judiciary. So that's something to keep in mind when you're considering, is it worth it on the front end to try and work on co-development agreements? If those wind projects are greater than that $253 million figure, then it goes to the Industrial Siting Commission. Notably, the Industrial Siting Commission and the application that has to be submitted to county commissioners differ in what they require. And likewise, Industrial Siting Commission has more rules and regulations in place, a lot more practice there. But keep in mind that, again, if you don't handle this on the front end, the Industrial Siting Commission is where you're going to be needing to advocate for your rights and appealing from there if you have to do so. So shifting to Texas, I found this and wanted to include it. I have yet to talk to a Texas practitioner that has actually used this, but I think it's an interesting idea, at least in the abstract. So the Texas Railroad Commission has what they call drill site designation, and it's under that statewide rule that you see cited there. And basically, it's a provision that allows a mineral interest owner to create a qualified subdivision. And what that does is it limits mineral interest owners' right to explore and produce to specified operation sites on a tract. And I misspoke a moment ago. It allows surface owners to create those subdivisions and otherwise restricts the ability of mineral interest owners to develop outside of certain areas. Now, there's pretty specific requirements for what it takes to put together one of these qualified subdivisions. The operation site for each 80 acres, it has to have an operation site that's 80 acres within the 640 acre tract, has to have certain easements in place, and those easements have to be within a certain size. But if you were in Texas, this is something you could possibly use. And this is a framework that we might be seeing used more often in the future as these co-development projects or these co-development conflicts continue to arise as projects proceed. So, federal policies or lack thereof. I know when I'm on thin ice. I appreciate having our regulatory folks in the room here because they have to make challenging decisions every single day about how they implement policy that they receive from the top down, policy that often changes every 18 months, as you heard, based on leadership from Ms. Watson. So I want to start out by saying that I recognize and appreciate what our federal regulators do as far as helping these projects as best they can. But that being said, the federal government has not really came out and said, listen, for federal lands, this is how we're going to treat co-development of projects, specifically renewable and traditional energy projects. So if I'm a company, and as we heard the first thing this morning, Governor Gordon speak about, if certainty is key for me being willing to invest capital into projects, how do I ascertain what I can from federal decisions that have been made up to this point? And so there's 3 examples that I want to look at where federal agencies have addressed co-development, usually between more traditional resources that may influence or give us some insight as to how they'll treat these down the road. So the first one is the case of Burr Energy Corp versus BTU WRUS Inc., a mouthful there. The long and the short about this is in Wyoming's Powder River Basin, there was an oil and gas lessee and a coal lessee, both of which had leased, at least in part, from the Bureau of Land Management. Now, there was a conflict that arose, as happens, between the two of them as to who had the dominant rights to utilize the lands that had been leased to both of them. So what happened was the oil and gas lessee, Bear Energy, went to the court and said, we would like a declaration that our rights are superior to those of the coal company. The dispute, as you can see there, started at the state district court, went to the federal district court, was remanded to state district court. There was an oil and gas commission protest, a BLM suspension request, went to the Wyoming Supreme Court, remanded to state district court, and then a second Wyoming Supreme Court decision. So for those of you in the room, I can probably imagine a few of the lawyers licking their chops, but for those of you that work at companies, keep in mind that these are hairy issues to sort out. So if you're looking at whether being proactive about co-development or sort of letting the dice fall where they may, keep in mind that this is a potential impact. You could be locked into litigation for a long time because these are not well-settled questions. So getting back to the specific facts of this case, in the relevant appeal, the court held that the federal government was a necessary party because the competing federal lease provisions placed decision-making authority over the operations conveyed to the lessees and their mineral rights. It was squarely in the hands of the Secretary of the Interior and their designees to make a decision about basically who had the superior right in this instance. The court said, unless and until BLM gets involved, we're not going to make advisory opinions. And it's up to the Secretary of Interior to make some sort of decision, and then we'll assess it from there. ultimately, the Bureau of Land Management, they refused to join the suit, and for good reason. But they did not elect to get involved. And so the takeaway is that eventually the part of the dispute that was related to the federal lands was ultimately dismissed, because without the BLM's input as a necessary party, there wasn't anything that could be done. So the takeaway from this is the Bureau of Land Management isn't necessarily always going to be able or willing to jump in and assess these issues for you. And so it behooves you, especially if you're operating or these projects are on federal lands, to be proactive about it. New Mexico potash. This is an interesting instance because there was no litigation. Some of the lawyers are probably pretty sad about that, but this was an example of the federal government taking a proactive approach to addressing these co-development conflicts. So New Mexico's federal lands are home to both oil and gas production and potash mining in the Permian Basin. And on December 3rd, 2012, the Secretary of the Interior issued a secretarial order and basically said, all right, folks, this is not far enough along that we can't do something about it. So here's some rules that I think we should all play by. They addressed co-development of those resources in this designated potash area that was in 2 counties in New Mexico by setting up some rules. It imposed stipulations on the federal government, or it imposed stipulations on federal oil and gas leases issued by the federal government within that area. At that point, horizontal drilling was becoming more and more not only prolific, but affordable. So they leaned on that to say, what can we do to utilize this where potash is still appropriately mined, but we can still allow mineral development? They set up designated buffer zones between the two to reduce the possibility of conflict as far as external operations, things such as power, telephone lines, roads, that sort of deal. And as you can see, it required consultation and drilling islands where both the potash miners and the oil and gas producers had to communicate about where those facilities were going to go. The takeaway from this is, in my opinion, it is a great example of potentially how the federal government could implement some sort of program, directive, rulemaking in the future to approach renewable energy and traditional energy co-development down the road. The nice thing about it is it was in advance, right? The situation wasn't in existence, and so they could be proactive about it. There was some in place, both production, but it was proactive. It told the parties what to do instead of trying to sort it out after there was conflict. Our final example is sort of a little bit of tantamount the other side. If New Mexico potash is an example of how things can go well when proactive management takes place, the case of Barlow and Hahn Inc. versus the United States is an example of how it can be very precarious. So Barlow and Hahn acquired 26 federal leases in southeastern Wyoming, southwestern Wyoming, my apologies, to the west of Green River, where they also had trona mining operations and trona leases going on. The BLM issued both trona leases to mining companies and oil and gas leases that were subsequently exchanged to Barlow and Hahn. And so ultimately, the Bureau of Land Management elected, once they completed their resource management plan for the area, to suspend the oil and gas leases indefinitely, which then led to a lawsuit with the Court of Claims. It got appealed to the federal circuit, and the court ultimately held that the claim was unright. And it was unright because Barlow and Hahn had never filed an APD. They didn't file an APD, so because of that, they weren't deprived of any property right, and so there wasn't any actionable claim for them to move forward on. That was the actual ruling in the case. Now, the practical takeaway is this. Although in this instance, Barlow and Hahn lost, they rolled the dice and lost. It could have just as easily been the trona miners who may have had their leasehold rights impaired. So I sound like a broken record, but this is another great example of why, if you're co-developing these projects, especially on federal lands, that it behooves you to be proactive about addressing conflicts. So that's what I want to talk about now. What are some practical takeaways for practitioners, both renewable and traditional energy lawyers that support both of those, what does this teach us about how to manage these conflicts moving forward? Well, first for mineral owners, if you're in a position where you need to make a claim under the accommodation doctrine, you actually have to try to develop your minerals. Unless and until you do that, there's nothing a court can do to help you. The second thing for mineral interest owners is if there's no other option exists for the existing surface use, as a mineral owner, you may be required to adopt a different use, even if it's at a greater cost to you, which can be spooky, right? For folks that have sunk costs and capital to try and account for to shareholders and that sort of thing, the last thing you want to be looking at is uncertainty as far as your expense. For surface owners, if there is no industry accepted alternative, the mineral owner can still develop despite whatever your existing surface use is. Keep that in mind. And secondarily, failure to adequately coordinate with a mineral interest owner can result in not only damages, but also removal of your stuff. So before you make an investment on the surface, you dang sure better be proactive about it, because without that, there is the possibility that you may be required to scrap all of it. So best practices, thorough title examination. Do you remember how we talked about in Midway Solar that they got surface waivers from folks that had minerals adjacent to the parcel where the solar panels were? That does you no good, turns out. So when you're doing co-development of projects, do a thorough title examination so you know all the parties that are involved, whether you're the mineral interest owner or the surface interest owner. Enter into surface use agreements and carefully consider the language there, because these questions, when it comes down to it, could be multi-million, if not multi-$100 million questions that you need to answer based on whatever your agreement is with either the surface owner or the mineral interest owner. Obtain valid surface waivers. It can be a pain. Landowners will hold out on you. They will want to get in certain provisions, and same thing, mineral interest owners won't necessarily budge when they should. But whatever those negotiations take on the front end, an ounce of prevention is worth a pound of cure in the long run. Consult with mineral interest owners regarding specific drill site designations. Without those, or with those in place, you are all but resolving the issue before it happens. It's a very simple thing that can be done and at relatively little expense compared to litigation. Also consult with independent geologic experts. If I'm going to build a solar farm and I'm doing it on somebody else's mineral estate, I would sure like to know if that is on top of the world's biggest oil play or not. So that's something that you can do to be proactive that's going to help you mitigate your risk. Include all relevant stakeholders. As I mentioned, make sure you get everybody involved in the conversation that ought to be involved. Include payment to mineral owners in exchange for waiving the right to occupy the surface. As we know, consideration is important in contracts, but it's amazing. There's a whole line of cases out there where agreements are negotiated, but without consideration, and they don't hold up in court. Require consultation or technical committees or some sort of formalized communication between the parties. The first time that you're thinking about having communications, clear communications with the other party, if that's when something's gone wrong, it is too late, folks. It's too late. So set up clear expectations for when and how you're going to communicate. Along those lines, when you communicate, address all aspects of development. It's really easy to think about, where does the well go? Where does the pit go? Where do the panels go? Where does the wind tower go? But think of all the collateral things as well. Transmission lines, housing facilities, roads, all those sorts of things that you wouldn't necessarily think about, but are critical and may cause harm for your relationship with the other party down the road. So this was one of the slides that I started with. As we have increased mineral development and increased renewable development, we're going to see more of these conflicts. You heard from tons of different folks on the stage today whose message was this: energy is critical and we need more of it moving forward. We can have arguments till the cows come home about what percentage is going to be renewable and what percentage is going to be traditional. But based on current projections, the plain fact is it's going to be more of both. And so as these conflicts come up, do your best as a practitioner to be proactive about addressing the problems so you don't necessarily have to worry about them on the back end. And my haunting, I guess, statement to you is this. If you get into a place where you're worried about application of the accommodation doctrine, It's fact intensive and you've already lost. Co-development agreements help keep your liability, your potential issues, resolution of uncertainty, and conversely provide certainty for capital expenditures in your hands. And that's where you want that to be. Thank you. I think we're about out of time, but I'd be happy for any questions if there is time.